Sure.
Good afternoon, everyone. On behalf of the Federalist Society at UCLA, I want to thank you for coming to our final debate and event of the semester.
Woo!
We're very excited and very grateful that all of you are here and that our speakers are here. So today's event, as you probably know, is on a highly contested part of our Constitution, the Second Amendment. So today's discussion will explore not just the historical foundations and original meaning of this amendment, but also the modern day implications, including the scope of regulation and tension between individual right and public safety. Today we're honored to have with us two outstanding legal minds to debate these issues. First, we have Professor Josh Blackman. He's a constitutional law professor at South Texas College of Law, a prolific scholar, and a nationally recognized commentator on the Supreme Court and the Constitution. He's the author of several books, a frequent contributor to legal blogs. You might have heard of the Ball of Conspiracy. He's a big member of that. And he's also a longtime Federalist Society speaker. Joining him also is Adam Skaggs on the far left here, I guess we're right. He's the Chief Counsel and Policy Director at Giffords Law Center. Mr. Skaggs is a leading voice on gun policy reform, and he has litigated extensively in defense of firearm regulations. Before joining Giffords, he was senior counsel at the Brennan Center for Justice, and he's argued some of the most important cases shaping the boundaries of gun regulation today. As for our moderator, I will turn it over to my co-president to introduce him.
Hi everyone, I'm Brent. Moderating today's discussion is another highly qualified individual, Alexander Robbins. He is the Deputy Chief of Appeals at the U.S. Attorney's Office in the Central District of California. Alex also helps run the Federalist Society's Los Angeles Lawyers chapter and brings both courtroom experience and a deep understanding of constitutional law to today's conversation. Each speaker will begin with brief opening remarks, followed by a moderated discussion and audience Q&A. There will not be a live Q&A, but you can ask questions directly, the old-fashioned way. As always, the Federalist Society does not take positions on legal or public policy issues. Our goal is to foster robust and respectful debate, and we hope today's conversation deepens your understanding of the Second Amendment, whatever your views may be. Now, with that, please join me in welcoming our speakers.
And I guess I'll take it away from here and give my disclaimer, which is whatever experience I may or may not be bringing to this lovely moot courtroom that you have here. I am not bringing any opinion or position of the United States Department of Justice or government whatsoever. That bio is by way of background, and I'm here entirely in my personal capacity. In fact, I'm actually taking annual leave to volunteer to be here because I think it's important that you all hear about, we talk about these issues too. So I think the introductions have been done. I'm going to be I hope to learn as much as you do from this debate. So with that, I'm going to let Professor Blackman kick it off with your presentation.
Thank you so much. It's good to finally be here. We were scheduled to come in January, but there were some fires, as you might recall, so we had to reschedule for the very end of the semester. But I'm here. Thank you so much to the chapter, my dear friends, for having us. When I went to law school, the Second Amendment wasn't really a thing, right? There were no Supreme Court cases of any modern relevance on the case. There were some old cases that kind of spoke around the Second Amendment, but didn't really talk to the issue. But that changed while I was in law school. I was a second-year law school, like many of you, when D.C. v. Heller was argued. I actually was a research assistant from the lawyers who argued that case back in the day, and they put forward an argument that, frankly, had not gained acceptance in the courts quite yet. That the Second Amendment protects a right that's individual, that is not connected to any sort of malicious service. When they first filed that case, the Supreme Court had 9 members who were a bit different. You had Justice O'Connor. And it was never clear if there were going to be 5 votes for the Second Amendment at that point. In fact, the NRA, we have stuff with the NRA, they never wanted Heller. Did you guys know that? The NRA fought Heller because they were afraid it would be a loss. And it would be better to have this weird status quo than to have a clear defeat. But while Heller was being litigated up to the Supreme Court, Justice O'Connor stepped down, and she was replaced by Justice Alito. Justice Kennedy was still sort of the swing vote. And it goes to the Supreme Court, and we get a decision in the summer of 2008, when I was a summer associate, and it was kind of surprising. The decision was the Second Amendment protects a right of individuals to bear arms not connected to militia service. The majority was Justice Scalia. The court split 5-4. Justice Stevens and Justice Breyer wrote separate dissents, and they were, in many regards, applaudable. Why? They were originalist. This was one of the first cases, at least in my memory, where a major constitutional issue, a 5-4 case, had a majority that was originalist and a dissent that was originalist. That, I think, is a victory for originalism, no matter what you think about the Second Amendment. And I'm sure Adam and I will talk about some history, we'll talk about Blackstone, maybe talk about the English Bill of Rights, but we're making arguments grounded in text, history, and tradition. That is a good thing to make. We're not making arguments based solely on public policy, what we today might think is the best answer. Okay. About 2 years later, the court decides another case called McDonald against Chicago. This was kind of like a follow-up case, right? DC involved, was there a federal right to bear arms? McDonald was, is the Second Amendment incorporated, that is extended to the states? Again, the court split 5-4-ish. And I'll explain why ish in a minute. 5 members agreed that the Chicago gun ban was constitutional, but they didn't agree on the rationale. Justice Alito wrote the plurality opinion for 4 members who said we will use the due process clause to incorporate what's called substantive due process. Justice Thomas did not go along with that. He would have used what's called the privileges or immunities clause of the 14th Amendment, a very important thing. So that the right to bear arms is a privilege of citizenship. But no matter how you slice it, the Second Amendment now applied nationwide. But Heller and McDonald on their face didn't decide everything. Both cases involved, could the government, either federal or state, ban the possession of handguns in the home? The questions were not resolved, carrying outside the home. Questions were not resolved, what kind of arms can we have? Questions that were not resolved, what kind of background checks can be had? The court also had this paragraph, which people love to quote, where they said, here are some limitations we don't question. For example, you can ban guns in so-called sensitive places, that dangerous and unusual weapons can be banned, that perhaps people with mental illness might be deprived of the right to bear arms. And there were a couple other exceptions. And maybe this was Chief Justice Roberts, maybe it was Justice Kennedy, we don't know, but these were not historical, right? They kind of just said, here are these long-standing prohibitions that we do not question. All right, so McDonald was 2010. What happened to the Second Amendment in the 10 years after McDonald? Not much. Lower courts, especially this one, the Ninth Circuit, almost consistently upheld just about every gun law that came to the courts. The courts broadly read the term sensitive places. They broadly read what dangerous, unusual weapons are. They developed this kind of 2-step framework. It wasn't strict scrutiny. It wasn't kind of intermediate. They called it heightened scrutiny. I won't bore you with the details, where they determined that most gun laws fit within the scope of the government's regulatory power. And in case after case, gun rights groups, which I've been involved with, brought these suits and they lost. Now we were hoping, praying maybe, that the Supreme Court might take a case eventually, that the Supreme Court might grant review in something, maybe for what's called an assault weapon. It's not a real thing, it's just a gun with a lot of stuff on it, right? Maybe a case about concealed carry, right? Maybe a case about waiting periods. Maybe a case about a non-violent felon who seeks to have his gun rights restored. But in case after case, the court kept denying cert, one after the other. And then by 2015 or 16 or so, Justice Thomas started dissenting, saying, wait a minute, we got the Second Amendment here. Why are we not taking any cases? Isn't it our job to clarify the scope of these rights? And Scalia started joining him. Then Scalia died. And this was an important moment. When Justice Scalia died, many people thought, okay, we'll have President Hillary Clinton, okay, and then we'll have a justice like maybe Merrick Garland or someone else on the Supreme Court, and they will push the court to the left, and maybe they'll even reverse Heller. Or if they don't reverse Heller, they'll just say, no further. You keep a gun in your house, you can never leave your house. That's it, no more. And basically the Second Amendment would be a dead letter for the Constitution. But then, against all odds, President Trump prevailed, and he put Neil Gorsuch in the court. He put he put Brett Kavanaugh in the court, put Amy Coney Barrett in the court. So finally then, after almost a decade of cert denials, the court grants a big case. This is a case called Bruin, right? New York had what's called a May issue regime for carrying a gun. California, I think, has something similar, or had something similar, I should say. The idea was, if you want to have a gun, you must show some special needs, some special justification to have a firearm. In practice, this meant if you were friends with a sheriff, you'd get your permit. If you were a celebrity, you got your permit. If you were a VIP, you got your permit. And if you're just a random person who lived in a rough neighborhood, good luck, because you're not getting your permit. It was just denied in often an arbitrary fashion. So perhaps it's a violation of due process, right? Maybe the government can't have such an arbitrary standard. I think it's actually a decent argument. But the case was pressed as a Second Amendment case. The lower court, the Second Circuit, all upheld the May issue regime, and the case then goes to the Supreme Court. Okay. This case was decided in June of 2022. Let me tell you, this was a very busy time for the court. Because what else happened in June of 2022? Dobbs, abortion. What else happened in June of 22? Kennedy v. Bremerton, Establishment Clause. In the span of 3 days, my friends, 3 days, the court decided, landmark case, overrule Roe v. Wade, overrule the Lemon Test, and then say that the right to bear arms extends outside the home. This was the most intense 3-day period that at least I can remember in my lifetime on the court. Even more intense, the Supreme Court assigned the opinion to Justice Thomas, who is the most ardent originalist on the court. And Justice Thomas put together a framework that said we need to review the Second Amendment using circle analogies. Remember the SAT, the LSAT? If this is like that, this is like that. Remember these questions? So, was there any regime in which the government would preemptively deny someone a handgun license unless they had good cause? And Thomas said there's not. So there's some evidence. There's history of, for example, if a person proved they were dangerous, you take their gun away. And maybe if they wanted to carry a gun, maybe made them post a bond, what's called a surety in advance, but they would be able to carry their firearm. But Thomas said there was no historical analog that fit the kind of regime that New York State had imposed. Okay, so that was Bruin. Again, a landmark case, again, a 6-3 decision by the Supreme Court to recognize the right to carry outside the home. And in the wake of that, California and other states had to modify the regimes. All right, fast forward like a month, and my beloved Fifth Circuit, where I live, decided a case called U.S. Rahimi, R-A-H-I-M-I. Now, Zaki Rahimi is not a good dude. He had a bad habit of shooting at people. He shot up a Whataburger. He abused his girlfriend. He was a bad guy. I will not argue with him that one. And he was subject to what's called a DVRO, a domestic violence restraining order. Again, he had been abusing his girlfriend. This is not a clear, an ambiguous case. He was bad. He should have been subject to this order. When you are subject to a DVRO under federal law, you are called a disqualified person. You cannot have a firearm under federal law. Of course, he had a gun. He was arrested. He wasn't charged with domestic violence or battery or anything that makes sense. He was charged with felon in possession or individual in possession under a restraining order. Okay. Initially, the court said your conviction's fine, but then after Bruin, the Fifth Circuit decided a case called Rahimi, and the Fifth Circuit said, aha, there is no tradition of taking guns away from people who are under domestic violence restraining orders. And as a practical matter, that's probably true because there was no such thing as a domestic violence restraining order. But let's say, a little bit more broadly speaking, you didn't have a practice of disarming people in advance of the crime, right? If they committed the crime, you take it away, but you wouldn't disarm them in advance. So the case goes to the Supreme Court. Now, did the Fifth Circuit accurately apply Bruin? I think they did. I think the Fifth Circuit actually got Bruin correctly. But the funny thing happens. When the Supreme Court doesn't like one of their precedents, they change it. They just don't tell you about it. And so the court grants cert in Rahimi. Chief Justice Roberts writes the majority opinion, and they, shall we say, clarify the Bruin standard. They say, well, we didn't actually mean that. And the Chief Justice says, we don't take history quite that seriously. So, if there's some precedent about, taking gun away after you commit a crime, there's another precedent of, we make you post a bond before you commit a crime, we can just merge those. Yes, there's a tradition of disarming dangerous people. That's not how Bruin works. And in fact, Justice Thomas dissented in the Bruin case, saying, what happened? This is not what we wrote just over 2 years ago. But you want to know what happened? Justice Thomas had no other votes. He was all alone. So the court shifted Bruin. So now we're in a place, now my time is almost up, we're in a place now where you had this broad precedent being set in Bruin, and the court then pulling it back in the Rahimi case. And I don't know what the court's appetite is to even take more gun cases. There are a number of pending petitions, some of your group filed in them, involving assault weapon bans, of different non-violent offenders, and the court's just not granting. In fact, they're probably going to have some dissents from denial coming up in the Maryland case, a few others. So I think the court's going to take a sabbatical on the Second Amendment again. It's like, all right, you got the right to carry. We're not going any further. And so as much as I might want there to be a very robust Second Amendment protection, we're not going to see it. And on your beloved Ninth Circuit, there's actually a rule, it's a local rule. Any favorable Second Amendment decisions immediately en banc. It's actually, it's the rules. You have to just look very closely. Mostly joking. But there's never been a single Second Amendment case come out of the Ninth Circuit panel that wasn't en banc. Judge Van Dyke has the receipts in that one. And so here we are. All right, my time is up. Thank you so much. Welcome to hear from my friend and your questions later.
Thank you very much. Mr. Hayes.
Thank you. You know, when I walked in, I saw the sign said Second Amendment Showdown, and you know, I hope folks here aren't expecting, you know, fireworks and heated exchanges, because if so, I've probably let you down. And I've actually found that on this issue, a lot of these kinds of conversations end up actually revealing more common ground than they do fireworks and heated disagreements. I'm sure we will find some things to disagree about. Hopefully we'll do so, you know, agreeably. But I don't really take issue with, I think, anything that you've heard so far. I think in terms of the history, that's all fairly accurate. Whether Heller's embrace of originalist methodology is a good thing or bad thing, maybe we don't see necessarily eye to eye on that. But I think the historical account that you got of the development of the law in significant cases is pretty accurate. The only thing I would say, in terms of those of you who may be interested in the history, particularly of Heller, is that I put in a plug for your Professor Adam Winkler's book.
Yes, Gunfight. Excellent book.
I see one of Professor Winkler's and my former students is here, so welcome. Good to have you. And it's a great account of Heller and kind of the story behind it and how it came to be. So without rehashing all of that history, I'll sort of fast forward through that account to the Bruin case, because while it is certainly the case that Rahimi put a new spin on Bruin's test, I think we're still living under the Bruin framework. And what I mean by that is it's certainly the case that Bruin was about New York's May issue concealed carry permit. And to be clear, this was a permit to carry guns and, you know, concealed weapons in public. It wasn't about owning a gun in your home, which Heller had already addressed. And obviously that rule, that requirement was struck down in New York, California, and about a half dozen other states. They have now embraced a different regime that essentially is a more objective. If you satisfy these conditions, you know, you'll be granted a permit. Even with these new shall issue regimes, there are concerns about how they're being applied, and the Justice Department has just identified the Los Angeles Sheriff's Department as, I'll just say, acting too slowly in processing applications for concealed carry. So there's an investigation ongoing as to whether here locally that right to carry guns in public is being implemented fairly. But leaving aside the issue of May issue and the scope of the ability to carry hidden guns in public places, and whether that extends to private businesses that don't want people carrying guns inside, let's say a shopping mall or a supermarket, leaving all those issues aside, what I want to focus on a little bit with the Bruin is the methodological leap that it made, in which it took this really unanimous position that the lower courts post-Heller had come to embrace, this two-step methodology, which first looked at history and sort of asked whether there was a clear answer to whether historically this particular type of regulation, the right that was impacted, clearly fell within or outside the scope of the Second Amendment as historically understood. But then went on to step two. If indeed the Second Amendment was implicated, then courts were directed to apply some sort of heightened scrutiny. If it was, you know, close to an absolute prohibition on the right in question, strict scrutiny was appropriate. Lesser burden, lesser imposition, something more intermediate scrutiny applied. And it is true that after Heller, the majority of cases using this methodology upheld gun laws that were challenged. Now the numbers are a little skewed because the vast majority then and now of challenges to gun regulations are brought by people facing criminal charges, charged with being a felon in possession illegally, sort of like Mr. Rahimi, but usually it's a felony conviction, not a restraining order. And Heller had said, in no uncertain terms, we can argue whether it was dicta or not, but Heller had said nothing in this decision cast doubt on such longstanding prohibitions as, such longstanding regulations as prohibitions on gun possession by felons. So with a clear and unambiguous statement like that, courts have said, look, Heller said that these laws are constitutional, and they rejected those. So the notion that courts were really striking down every challenge is a little bit skewed, because the vast majority of those challenges are challenges that Heller said are really easy to reject. But the lower courts came up with this two-step methodology, and it worked for a decade. When Bruin threw that out, not only did they overrule or strike down New York's law, but they also said this two-step methodology is no good. We're only going to look to history, and we're only going to look and see whether a regulation is consistent with our history and tradition. And there's a textual inquiry at the start of that. But basically, we're going to look to history and tradition, and that's going to be a more reliable way. It's more consistent with the meaning of the Constitution, and it's going to stop this, rubber stamping of these judges who don't like guns. It's going to lead to more predictable and more consistent outcomes. It's a better test. And so here we are. Having seen what I would have thought, what I did think at the time was a pretty high volume of challenges to gun laws preceding Bruin, boy, I didn't know what a big volume of cases was until after Bruin, because the number of challenges filed just exploded. And we saw a real increase in the number of laws being challenged. We saw groups that were challenging these laws seemingly being incredibly well-funded and well-resourced to be able to bring these. And so we saw an expansion in the number of cases challenging gun laws. Now, we also saw, in contrast to Justice Thomas's predictions that we would have this, reliable, uniform way that courts would all reach the same conclusions, and that judges would not bring their own personal sort of policy views into assessing Second Amendment challenges. And in fact, what we saw was pretty much the same as before Bruin, that courts were reaching diametrically opposed positions. And sometimes those conclusions reflected the party affiliation of the judges prior to their confirmation, but sometimes not. And so I think where we are under the Bruin methodology is in a very uncertain and unstable place. I think the Bruin methodology has not given courts and judges a way to hear cases that are not influenced by personal ideology or the judge's policy preferences. And all those critiques of the consensus test prior to Bruin, I think, could be made just as much to the cases after Bruin. So the test has not proven any more reliable in getting to quote unquote the right answer. As we all know, that's no way to know such a thing, but it's proven unworkable in terms of getting a reliable series of outcomes. And on issue after issue, we see circuit splits developing. You already heard some of the types of cases that have petitions pending at the court. Minimum age laws is another area that is ripe for the court's review. We have circuit splits on whether 18 to 21-year-olds enjoy the same rights as adults. So it's proven unworkable in that way. I think it's a problematic methodology as well, because it asks judges to do something judges are not trained to do, which is be historians. Judges are attorneys. They've gone to law school like all of you. That's where their expertise lies. But all of a sudden they're told, well, in this one area of constitutional law, throw your legal training out, you're a historian now. And I think that's an area that they are not particularly well suited to be making inquiries, nor are oftentimes the advocates who are presenting both sides of the argument here. So we have this attempt to we have this attempt to understand the meaning of history by people who are not trained nor particularly competent at doing that. There's also, I think, some problems with the notion that if we look to history and we don't see a specific analogous, very closely analogous law to what the California legislature passed in 2025, let's just say, this law can't be upheld. Well, did legislators in 1791 fail to pass a similar law addressing a new type of problem that legislators today are passing? Did they not pass that law because they thought, well, we can't do that, that would be unconstitutional? Or did they simply say that's not an area that needs to be regulated? So the test looks at the absence of certain kinds of regulatory decisions and gives them significance. I would suggest that those decisions don't always support. I think failure of a legislature to address a certain type of problem does not mean that if that problem were more serious, the legislature couldn't address it. But that's sort of baked into the Bruin methodology. But beyond all those sort of practical problems with the Bruin methodology, I think there's, I guess I'll call it a normative one, which is, and this may be an audience of originalists, so forgive me for not being the biggest fan, but I think there's some questions about the wisdom of looking to a period in our life where most of the people in this room wouldn't have enjoyed the vote, where certain members of the American community were viewed as property and were enslaved, where women were not part of the polity, didn't have the right to vote. So even if some of these other problems with looking to 1791 and the laws that were passed then as the types of law that we should have to address modern firearm technology, modern problems with mass shootings and with violence, even if there weren't those practical problems, I would suggest that looking at the decisions that legislators made representing that polity may not be the right reasons we want to support laws made by a very different polity under very different modern circumstances in which the American political community has expanded dramatically. So I think even going beyond the practical challenges with a methodology like Bruin, there are some real questions about whether, when we're looking at contemporary problems addressed by contemporary representatives, democratically elected representatives of the people, whether they should be held to the same rigid constraints as a very different group of legislators over 200 years ago. I think we're going to probably get into some of the specific restrictions. You've already heard them referred to: minimum age, assault weapons, restrictions on sensitive places. So I think rather than saying more, I'll kind of leave my initial remarks there and hope that we can get into addressing some of the details around some of the specific policy areas.
All right, thank you, Mr. Skaggs. I want to pop in with a moderator question, actually, to ask Professor Blackman to respond to something that you said that caught my attention. So one of the things, as I know you both know, that Justice Thomas had written about in his various dissents from denial of certiorari in that 2010 period was that he wanted the Second Amendment, I think in his words, to be treated as a real constitutional right and treated along the same lines as the First Amendment.
Mm-hmm.
And it occurred to me on your methodological point about looking at history and tradition that there may be similar historical problems, in your view, with judges looking to history and tradition when interpreting the First Amendment, for the reasons you gave. It's been around for 200 years. Judges aren't historians, all the things you said. I guess I wanted to ask a quick follow-up to you. Do you have any thoughts on, do you believe that there are similar methodological problems presented when interpreting the First Amendment? And then I'd like Professor Blackman to have a chance to respond.
Sure. Well, let me be clear. I think there's a place in constitutional inquiry for reference or examination of history and tradition. And indeed, prior to the Bruin case, that was part of the Heller test, the test that courts had developed after Heller. It just wasn't the beginning and end of the inquiry. There were additional factors that were looked at, such as social science data on the effectiveness of whether a gun law helped prevent people from being shot and killed. So, look, I think in the Second Amendment context, in the First Amendment context, or otherwise, looking at history and tradition can and often is helpful, and it can be an important part of the constitutional inquiry. I just think suggesting that using history and tradition as a straitjacket to address contemporary public safety problems in this context usually is not appropriate.
So let me answer the question this way. Justice Thomas said for the better part of a decade that we shouldn't treat the Second Amendment as a second-class right. And the usual response is, well, the Second Amendment's different, right? It's a dangerous right. People can get injured by the Second Amendment. Do you know what's dangerous in our Constitution? You're a federal prosecutor, right? The Fourth, Fifth Amendment, Miranda, the exclusionary rule, right? We have all these prophylactic rules put in our Constitution by the Supreme Court, which have little basis in law, that let bad guys get out of prison. There are lots of dangerous rights. The Second Amendment is not alone. In fact, we primarily argue for law-abiding citizens to have gun rights. These people who commit crimes at very low rates, for like people with concealed carry permits, it's a very low rate of breaking the law. Okay? Now, as for the First Amendment, I think there's an even bigger problem. If the court took seriously the history of the First Amendment, Judd Campbell is professor at Stanford, up north, I think, somewhere there, he's made the case, maybe not convincingly, but I think quite well, that most of our free speech doctrine is wrong. I mean, other than maybe prior restraints, maybe some limitations on seditious libel, that's about it. So obscenity, pornography, that can be banned. On religion, though, establishment clauses look a lot different. At the framing, we had established churches. There were literally established churches and states. So I take my friend's point that maybe we shouldn't be governed by a document written 200 years ago. I think the answer then, perhaps cliche, is we should amend it and change it. But I think the Warren Court sort of tells us, oh, we can just fix our problem by just rewriting the Constitution, just make it up as we go along. I think that's actually left us in the state. Now, I favor the Constitution as it's written. By the way, it's not just 1791, it's 1868. If you look at the Reconstruction era, there were very strong discussions of the right to bear arms for the freedmen. By the way, Dred Scott, you know Roger Taney said that black people can't be citizens because they can't be trusted with guns? He said, it would never be imaginable that people have the right to bear arms, that black people have the right to bear arms. He said that. 14th Amendment reversed that. So there's actually some good history that whatever the right to bear arms meant in 1791, it's even stronger when you get to Reconstruction. That's why Thomas wrote McDonald, I think, absolutely correctly. I think I answered your question.
Can I throw in a plug, I think, without expressing an opinion on the merits? Justice Thomas's separate opinion in the McDonald versus Chicago case, I think you both agree, is a fascinating read on the history of the 14th Amendment and the Second Amendment and some of the intersection of these issues. For the law students in the audience, if you want to learn about the 14th Amendment, I'd recommend that. Do you, Professor Blackman, see any problem, practical or otherwise, with the history and tradition test under the Bruin framework? And in particular, is there, in your view, if Rahimi got it wrong, and the Supreme Court, the same court, was applying their own test that they came up with a few years earlier, is that a sign that there's any sort of problem with the test?
It's a fair question. So we always say text, history, and tradition. Okay, those are three items. Text, okay, what does bear arms mean? Okay, we did that in Heller, right? We basically got the meaning from the text. What's history? History refers to the stuff that came before 1791 when the amendment was adopted, or perhaps before 1868 when you ratified the 14th Amendment, depending how you view it. And then what's tradition? Right, tradition. Right. What's tradition? God, thank God in LA they laugh at that joke. Most places they don't get the joke. Hucksmacks, everyone, right? Tradition is what you've been doing for a very long time, right? It's you keep doing it, and eventually we say there's liquidation, right? There's a practice that's been around for a long time, and that becomes part of the Constitution. The problem with the tradition prong is that the New York Sullivan law, the gun law in Bruin, was 100 and something years old? That seems like a tradition, maybe? So I don't actually like the tradition part of it. I think it's actually problematic. The challenge, though, was how the Chief Justice construed history in the Rahimi case. Again, I mentioned this briefly, but I'll expand a little bit. He took two different historical elements. One, that if you're convicted of a crime, they take your gun away. That's number one. And two, that if you're considered a dangerous person, you have to post a bond, what's called a surety, to carry arms, right? And he sort of glommed these two things together to say, aha, that means we can take guns away from people after they're dangerous, so we can make sure they don't get in the first place if they're dangerous. That isn't really what the history tells us. And a lot of historical work, a lot of originalist work is how do we actually do what's called construction? How do we take a historical record and apply that to a set of facts? And I think what the chief did was he did a Houdini. Robert says the thing, just Houdini. He's like, look over there, here's a bunny, right? And he distracts you, that makes sense, but it actually doesn't work well. If you take the Roberts approach well, that you have a power to disarm people who are even potentially dangerous, right? Who've not been convicted of a crime, I think it goes very far from what was in history. So the challenge is not Bruen. The challenge is a judge's fortitude to actually apply Bruen. Look, Justice Kavanaugh could not stomach giving a gun to a wife beater, right? Justice Barrett wouldn't do that. Gorsuch either. He had this weird concurrence, like, facial challenge. He couldn't go along with it. The optics of the case were so bad. Like the U.S. government, if they had any plaintiff or any test case, this was the case they wanted. Look at Mr. Range, right? Who's Mr. Range? This is a guy who lied on a food stamp application to feed his family.
You should tell them about the Range case.
Yeah, Range v. Holder, or Range versus Garland. I can't remember the final style. The guy's name was Range, R-A-N-G-E. He was convicted many years ago of food stamp fraud. They lied on an application for food stamps. He wanted to feed his family, and that's actually a felony under the law, believe it or not. Almost no jail time. Did he even have jail time? I don't think he had any. But he was a felon, so he's disarmed for life. Does anyone think this guy with no criminal record, his only crime is lying on a food stamp application, should be disarmed for life? Of course not. But the government got Rahimi to the court first before Range, and that was the case they decided. Very different world if Range was up first. And by the way, there were attempts to drag Range out. The government, we'll take our time, this and that. So there's a lot of chicanery, but they got the case they wanted, pre-logger, the SG, and she did.
Sorry, any attempt to either rebuttal and or defend the federal government's position in Range?
I don't, well, leaving aside Range, to get back to Rahimi, and I think Rahimi, you can say that it was a stage fright. They got up and blinked, they saw the real application of the Bruen test and thought, we got to do something about this doesn't look good. There's another way of looking at that, which is, if indeed it is the case that, as the Fifth Circuit found, that Bruen tells us because, spousal abuse was not criminalized or prohibited, 200 years ago, we can't do it today. I mean, that's sort of the problem that I was alluding to earlier, the notion of looking to these historical periods for the types of law that are appropriate today. Then, Rahimi was correctly decided by the Fifth Circuit. That to me, because I would like to think there's probably, maybe I shouldn't make assumptions, I would imagine there might be more than a majority support in this room for the idea that somebody who's been involved in 3 or 4 shooting incidents in the months leading up to his prosecution here, and is subject to a domestic violence restraining order for beating up his girlfriend in the parking lot, that person shouldn't have a gun.
You already assume they're all originalists, so we can.
No, that's what I'm here for.
We're not all originalists now.
But
the Federal Society takes no position on any issue, so you have no idea what these people do.
But I think,
I do.
Justice Roberts, there were 2 ways that the Rahimi court could have gone. They could have gone, you know what, we didn't realize this 2 years ago when we signed on to the majority opinion in Bruen, and that was wrong, so we'll overrule it and go back to where we were before. Or they could say, look, this can't be the kind of historical straitjacket that I've suggested it could be, and therefore we have to look at how courts are looking to history and understanding and analogizing. And I think what Chief Justice Roberts did there was say, look, you can't be so narrow in looking for precise analogs. You have to allow a little room for generality here, and in doing so, you should look not to the letter of these, the 18th or 19th century laws on the statute books, but you should look to the principles of those laws. And looking to the principles allows sort of broadening the aperture, so to speak, of how you understand these laws. And if you look at sort of what were the goals, what were they trying to do and how were they trying to do it? What Bruen arguably allowed in by Justice Thomas said, when we look to do historical analogizing, we can look to the hows and the whys, how laws work and why they were passed or why they were adopted. And so I think that you can think of that as an exception or a caveat, but however you want to think about it, that exercise in forming analogies, the Rahimi court said, look, we have to look at that at a higher level of generality, and the types of laws that said dangerous people can be prohibited from having guns. Here's a guy that a court explicitly made that finding, consistent with due process, a hearing that he had the opportunity to be heard at, and they entered a restraining order finding him to be a dangerous individual, which I think was probably the correct finding in that case. So the court said, look, if you look to the principles of our historical approach to regulating guns, one of the things that's pretty clear is if somebody's adjudicated to be a dangerous person, they can be disarmed. So I think Rahimi was correctly decided, lest anybody not be clear on that. And I think perhaps they sanded off some of the worst edges of Bruin and its historical and tradition-based test, but they did so in the guise of maintaining that test, and so judges who are predisposed to strike down a gun law to burnish their pro-Second Amendment credentials, or conversely, judges who maybe are hostile or believe that legislatures should get a lot of deference when they pass gun laws, they're still under that Bruin test that they can kind of pick and choose which analogies they like and respond by upholding or striking down the laws in question. And whether it's minimum age, whether it's a circuit split, whether it's regulation of assault weapons, whether it's from circuit to circuit, or whether it's even a district court who issues a decision that's reversed on appeal, the same judges looking at the same information are reaching diametrically opposed positions. So anybody, you say what you will about the Bruin test, the prediction that it would lead all courts to reach the same correct conclusions, I think categorically you can't have confidence in that assertion. Just within the past couple of weeks, the latest en banc Ninth Circuit decision has come down, finding that it is consistent with our historical tradition to restrict access to magazines that, this California law, of course, magazines that hold more than 10 rounds of ammunition, whereas the district court in that case, decision by a judge who struck down basically every gun law that he's had occasion to consider, have reached diametrically opposed positions. So, did Rahimi substitute a new test for the Bruin test? Did it make the Bruin test more practical, more viable to use? You can characterize it in a lot of different ways. But in any event, in upholding that incredibly important federal gun law and the principle that domestic abusers who've been found by judges to pose risks to their families or their intimate partners it should be permissible to disarm those individuals.
And to be clear, you're talking about Rahimi now, not the en banc.
Correct.
The magazine size.
Switch back.
Yeah, the California law was a magazine size, I think, capacity. Okay. That's two
It's a case called
two different
Duncan
cases.
that they just issued a en banc opinion.
It occurs to me, listening to this, that both of our esteemed speakers are in the position of sort of thinking that the law as it exists right now is wrong. I think Professor Blackman thinks that Rahimi was incorrectly decided as a matter of law, at least. Now, obviously, he's a horrible human. And Mr. Skaggs thinks that Bruin was wrongly decided. And at least in my work, generally, when we argue a case, we sort of have to convince ourselves that all the precedent, sort of cutting both directions, is correctly decided. Sort of internalize that, yeah, because we have to present a case to the panel of judges who's following precedent, who's going to agree with us. And I guess I want to ask you, it seems like both of you, along these lines, anytime you have a new legal decision with a new test, there's going to be back and forth by different judges applying the test differently and coming to different outcomes. They just might be in different spaces, right? So if you have one test, they might be disagreeing over here, and if you have a different test, they might be disagreeing over here. But that's just a natural, you guys are in law school, right? That's how the case method works. You have a rule about negligence, and then you have, a rule that doesn't apply when there's contributory negligence or something, and we sort of home in over time on the sort of nuances of this rule. And so I guess, is there a case to be made, maybe starting with Professor Blackman, that in fact the law we have right now with Brahimi as a portmanteau together is correct?
You say Brahimi?
Brahimi.
Brahimi,
Bruin
okay.
and Rahimi. I think David Latt has it as a portmanteau. Brahimi is the combination of the two cases. Is there any case to be made that Bruin and Rahimi are collectively
Or ruin,
Right.
or make it ruin, perhaps.
Bruin and, no, but the
no,
two
with R, ruin.
Ruin?
Raheem, ruin.
I mean, we'll see if it catches.
Yeah.
You're the Twitter
Uh,
followers.
Right. So good. I think you can reconcile them. In fact, if you read Rahimi, Chief Justice Roberts says, "Oh, we're applying Rahimi, we're applying Bruin faithfully." The problem then is that Justice Thomas wrote Bruin. He certainly knew what it meant. This is inside baseball here. I don't think Thomas had 5 solid votes in Bruin, and I'm actually kind of surprised that majority opinion held. I mentioned earlier that this was decided the same time as Dobbs, the same time as the Coach Kennedy case, the same time as Brett Kavanaugh had an assassination attempt that the court basically shut down on security lockdown. I think that if the justices were talking to each other more in that period, the clerks were able to shuttle diplomacy, that the Bruin majority was not held. That's my theory. I have absolutely nothing to base it on. But I think that majority held together because of the circumstance of the day. If you read the concurring opinions in Bruin from Chief Justice Roberts and Justice Kavanaugh block quoted Held said, "We do not challenge these long-standing prohibitions." He block quoted that again and again. And that's Kavanaugh saying, like, look, we'll go along with this. Bruin should not have been a hard case. I know maybe Adam thinks it's wrongly decided, but having this sort of discretionary review to have a firearm that was based on not much, that was, I think, actually hard to defend. I know the Second Circuit upheld under the 2 separate regimes, but I think that was hard to defend. What I think the challenge was that the majority in Bruin didn't really want to go further than this. Now, someone said, how could they have anticipated Rahimi? Well, anyone could have anticipated. That's not hard. How many thousands of DVR cases are in the system, right? It's not like a made-up situation.
Wasn't
right?
Emerson like the original Fifth Circuit case?
Oh, you're right.
Was
Yeah.
a domestic violence
There's so
case.
many DVRO cases, felon in possession. There's so many of these cases in the pipeline. Anyone could have known this was coming. So it's not like it was a surprise or a shock. I just think, and this is my inside baseball, they weren't able to engage in sort of usual deliberations they could have because they were locked down. They couldn't talk to each other. They couldn't exchange papers because of the security leak. Again, who knows if the Dobbs leak hadn't happened? Maybe the Dobbs majority would have broken down also. So it's sort of these accidents of history. And I think Rahimi cleaned up what Roberts couldn't quite get done in the Topps case and in the Bruin case. That's my opinion. I didn't really answer your question. That's what I think.
Mr. Skaggs, do you any case to be made for the current law at Bruin and Rahimi
I'm
together?
sure there's a case to be made. I'm not sure I'm the one to make it, but I think a lot of that sounds right to me. I also don't have any inside baseball about the negotiations around the Bruin test, but if you look at the concurrences, it does very much look like some of the justices that were part of the majority were like, we're not really fully on board with this whole thing. And it's not just looking at the federal prosecutions that would have suggested to the judges that a case like Rahimi could be coming. I don't know how many dozens of amicus briefs said, don't do this history thing, because let me tell you some of the cases that this historical inquiry that's being advocated for will result in, and domestic violence laws were like the biggest and clearest example of why this historical inquiry, if taken literally, as Bruin sort of suggested it should be, is problematic. So the writing was on the wall, and I guess Rahimi is sort of the first iteration of trying to sort of get that majority a little more fully on board.
Turn back to another I can't pronounce that word. Methodological question. So, in Heller, which was written by Justice Scalia actually cited Kylo. You might remember from Fourth Amendment law. That's the heat sensor through someone's house, Fourth Amendment case, right? It's a search to use a heat sensor on someone's house, as an example of updating sort of case law principles that existed from the founding to modern circumstances and technology. And Heller made this point when talking, I think, about like types of firearms. In Rahimi, I think probably part of you disagree with. Chief Justice Roberts has that the law is not trapped in amber.
Amber. Oh yeah,
line,
like Jurassic Park.
that we have principles from Bruin, history and tradition, but history and tradition is not trapped in amber. And then a lot of action then ends up in litigation having to do with how narrow or broad your history and tradition test is. So, maybe in the gun space it would be like muskets for, ARs, but in the case of regulation, like in Bruin itself, right, it was keeping guns out of sensitive places like courthouses versus the entire island of Manhattan. So I guess my question is, how much play in the joints is there in this history and tradition methodological question of how narrow we're going to look at the regulation versus how broad, and how much of a difference do you think that's going to make in the cases in the pipeline and how they come out?
Well, again, I think the magazine case you mentioned from the Ninth Circuit's an example. I mean, was it 10 that live in California? Is it 10? I can't remember the number.
I think California's 10.
10. I mean, almost every magazine that you buy in common purchase has more than 10, right? It's actually, you have to get special California versions to be under 10. If you want to talk about what's commonly in use, 14, 15, 18, 17, right? It's a very common number, right? But if you want to say, oh, well, at the founding, there were only muskets and those were single shot, so that's not there. Or you can say, oh, a magazine's not really part of an arm because it's, basically an accessory. I think when you have the Bruin/Rahimi test, there's enough play in the joints to find a historical analog for just about any gun control law. And if that's the test, right, then I feel like we're kind of wasting our time here with the history stuff. If virtually any gun law can be found to have some historical analog, then why are we wasting time with amicus briefs and historical research? We should just go back to almost a rational basis standard, which I'm sure Adam would probably appreciate, and say that almost any gun control law will be upheld short of banning a gun in the home and banning carry outside the home in all but sensitive places. I would almost appreciate that candor than making us go through the motions of researching and studying the historical periods. I, for one, would actually construe history more precisely and look for a closer analog. I think there are probably a lot of laws that are on the books now that are probably unconstitutional. You might say, oh, you can't have a civil society with these sorts of guns. Well, welcome to Texas, right? I mean, we can compare murder rates in this city versus that city and so on, but Houston, Dallas, Phoenix, large cities in the United States, which have very permissive gun laws and they somehow function. I grew up in New York City. I didn't touch a gun until I was almost 20 years old. I think there's a fear of guns, and they think that if we just regulate them, there won't be any crime. I think that prediction, whether it pans out or not, I'm not going to argue in this debate. But I think, for the most part, judges who have private security forces and bodyguards when they travel, they have marshal protections, they don't worry about these things. We shouldn't have the Second Amendment defined by the worst of the worst, like a Zaki Rahimi. I think that there are a lot of other areas where law-abiding citizens assert rights, and you need to have more of a government burden to justify them. That'd be my position.
I mean, isn't that a basis for, in terms of predicting outcomes of the cases so far? That the law-abiding citizens have won and the terrible human criminals have lost?
Yeah,
Can you think
yeah.
of an
I mean,
exception to that?
Dick Heller. Who is Dick Heller? Dick Heller was basically a guard. He guarded federal judges.
In the Supreme Court.
Yeah. Right. The federal judiciary. Who was Otis McDonald? He was a black man, lived on the wrong side of the tracks in Chicago, who wanted a gun to defend his family. Right. Who were Bruin and Koch? I think was the other one. They lived in upstate New York, law-abiding citizens. No, Bruin was the government guy. It was Koch and Nash. Those are the two plaintiffs, and they wanted a gun because they lived in a rough neighborhood. Right. And you get a guy like Zaki Rahimi who shoots up a Whataburger. Right. That's not the plaintiff you want. You want a plaintiff like Yitzi Frankel, who's just an awesome guy. Right. This is not the people you want. Sorry. This is not the guy you want to be representing you. You want Range, the guy with the food stamp fraud. Most of the cases, by the way, the Ninth Circuit brought by law-abiding citizens. These are not felon people who have these devices legally.
Supreme Court.
They're facial challenges brought to these statutes that fail.
I guess, yeah, rebuttal, and actually, if you have, I mean, you guys are the experts. Do you have any data points for the audience about like a counterproof to the notion that law-abiding citizens have pretty good win rate in the Supreme Court and that criminals have a pretty bad one so far?
Yeah, no, I think that's true, and there's a study by two professors, Professor Eric Rubin and Professor Joseph Blocher, that did a rigorous empirical analysis to test this claim that after Heller everything was just being rubber-stamped. And they said actually there's a little bit more play in the joints. This gets to the point I was making before about the numbers being skewed by the vast number of appeals of people charged with being a felon in possession. And they found that if you look at groups, at lawsuits that are brought by nonprofits dedicated to gun rights on behalf of private litigants, there's a much higher success rate. So I think that bears out the point that you're making. I just should thank Josh for so eloquently making the point I was trying to make before, which is that if there's so much play in the historical record that this becomes a meaningless exercise, maybe it's not the best test. Now, I think our approach to dealing with that problem, that this test doesn't work very well, is probably going to lead in opposite directions. He might apply history a little more rigorously or a little more strictly. I might say maybe we should go back to before where we looked at whether these laws work and whether they actually make any meaningful impact, and whether the number of lives being saved by an incremental, restriction on somebody's ability to carry a gun wherever they might want to is worth it, and whether those constitutional burdens are justified. That's the way I would go. I would put some of the data and public policy, the kind of social science, the kinds of things that we would hope legislators look at when they're trying to pass laws, that they'd inform themselves on whether this will work and whether the benefits will be vastly outweighed by burdens on law-abiding citizens or anybody else. That's what we did for 10 years after Heller, and that's what we're told we can no longer do now. Now, there's a little bit of, can we get the social science data back into the judicial equation by looking at this, what is the how and the why, and looking at the why, and well, if this many people died by gunshots before the law was passed, and that drastically reduced, the why was to save lives. So there's kind of a back door where it's possible to get some of this data, some of the the calculations on the benefits and burdens back into at least the back of the minds of the judicial officers who are making these rulings. But again, that's the reality of judges who understand the potentially that their decisions, the cost of their decisions might be measured in lives lost. Trying to figure out ways operating in what on its face is a very rigid historical inquiry to reach results that may be informed by other factors outside of what was on the books in a certain state or series of states in 1821 or 1868.
So do you think then that the test matters, the change in the test in Bruin does make a real difference in the ground? Because one of the complaints that some academics have sort of leveled against the Bruin history and tradition test is that it's sufficiently indefinite, and it requires, I think as you alluded to earlier, judges to sort of stray outside of their comfort zone enough that it becomes functionally indistinguishable from the sort of interest balancing test that you had post-Heller until Bruin. And I guess I hear you saying some of that, but also that it seems like you would prefer to go back to the old test. So let's give a chance to, what's your view on the question of whether there is any functional difference between a sort of looser history and tradition test on one hand and the interest balancing test on the other?
I mean, I think there's a difference because we've seen a higher volume of successful challenges to gun laws after Bruin. So clearly the test has, I suppose, been working for those who are hostile to these regulations. And yes, I do think, post-Heller we had pretty much unanimity, and obviously there were folks that took issue, or dissents or concurrences, took issue with that methodology, but by and large that was accepted across the country, and I think was a more rational way of doing constitutional analysis. If your choice is between being open and transparent about the factors that are being considered and baked into the equation, if you will, versus if you have a test where you're bringing in a lot of stuff sort of behind the scenes or without being transparent about it, without openly acknowledging that those factors are important in a judicial decision, I'd suggest the open and transparent methodology is a more appropriate one and is more consistent with the way most constitutional analysis
Professor,
is conducted.
sorry. Professor Blackman, what do you think?
Here's what I'd say. When you think about constitutional rights, there's really two important questions. First, who has the burden? The challenger of the government. And second, how strong must that burden be? Right? So talk about the tiers of scrutiny, right? What does rational basis scrutiny actually mean? The burden is on the individual, the citizen, to challenge the government action, show that the government action is completely irrational. Guess what? You're not going to win that test, right? The rational basis test is designed to make it almost impossible for the government to lose. And then you have sort of this intermediate scrutiny. You've seen it maybe in some sex cases, right? And the government says, well, the governments have, the burden is still sort of on the burden now shifts to the government, but it's kind of a more surmountable burden. Then you have a strict scrutiny standard, and they're the burden squarely on the government, and they have to show there's narrow tailoring, there's a compelling interest, a lot of these sorts of factors, right? That's how I think about rights. When you're asking about historical evidence, what you're really trying to ask is, does what the government doing now, right, does this fit within some sort of framework of how rights are being deprived? In my view, it's always the government's burden to justify the deprivation of rights. I think it's always the case. I think a lot of the Heller cases, which Adam mentioned, it wasn't clear that the burden was on the government. I remember there was one case, it was an Eastbrook opinion from the Seventh Circuit, where he basically said, well, here's some arguments the government raises, and I'm going to make up a couple other ones, right? And Eastbrook would do this. So imagine you're litigating a case and you rebut everything the government says, and the judge makes some stuff up that you can't respond to, right? That inverts a hierarchy of rights. I think Bruin, at least on its face, still requires the government to justify its actions, to justify it. That's only the first question. The second question is, how big of a burden is this? Is it, well, general gestalt, you can take guns away from dangerous people, or, well, there's no practice in history of taking gun from a person in advance, right? It's the second question that I think floundering, right? It's how strong that burden has to be. And I think what Rahimi did was they made the burden far easier. So at least on paper, the government has the burden. It's not on the citizens, it's on the government to justify it. But I think the burden's not quite large enough. And that's why I sort of think about rights. It's not just in terms of who wins or loses, it's how significant is that burden.
I mean, I agree with a lot of that. I think just your reference to the Easterbrook opinion gave me a chuckle because you're talking about reaching outside the record to come up with additional, I guess in this case, sort of legal theories. But the Duncan case that we've been talking about, if you're not familiar with it, there's a dissent from I think this is like the first TikTok dissent. There's a dissent from Judge Van Dyke.
Not yet.
Yeah, well.
To be clear, it was not TikTok, it was YouTube. This is an official U.S. government.
That's fair. That's fair. There's a little snark there. Sorry, but there is a judge, member of the Ninth Circuit, who felt compelled to supplement his written dissent with a video, a longer video than you might expect, in which he demonstrates what he sees as the flaws of the majority's opinion by demonstrating several of his own firearms, and of course none of this was part of the record, and includes his own arguments in a similar way to Frank Easterbrook. So it's good for the goose and good for the gander, so to speak.
I will throw in a plug again. It's not about me. A friend of mine heard about Judge Van Dyke's YouTube dissent in this case, and actually went and looked it up. And she said that she thought it was fascinating and very informative, and she learned a lot about guns. So it is out there if anyone would like
By the
to
way,
see it. It comes up pretty quickly on Google.
I actually know Judge Van Dyke pretty well. If you ever need an expert for guns to pass a Dalbert standard, he would pass. So he is an actual expert on. He knows more about. I take the point that's at the record. I'm not arguing that point now, but he actually knows what he's talking about. He really does.
Before we get too far on, we have about 10 minutes. You all have been a lovely audience and laughed at all of my jokes. So based on that, we're gonna open it up to some live questions with the caveat that they should actually be questions and short. Yes, sir.
Yeah, I figured
Jump in there.
I can't imagine why. I would ask about deprivation of rights. I applied for CCW October 29th, 2023. About almost 18 months ago. I have my appointment finally on Monday. And then I'm getting another at least 3-4 months. Is a right delayed not a right denied? I asked as well.
Yeah, obviously, at a certain point it is, if you're waiting for the license to exercise the right. But I think you'll be pleased that, with Pam Bondi's attention, those backlogs may be getting a
So this is actually a fascinating issue, and then maybe Adam knows this history better than I do. There's actually a statutory framework by which gun rights can be restored to people who are disqualified, but it was never funded. Am I right about that, Adam?
Not that it was never funded, but funding.
Right, it was funded, but then they stopped funding it, right?
Yeah.
So it's this weird thing where, in theory at least, you have the means by which the Attorney General can restore gun rights, but it's not been funded. Bondi has now said we want to consider doing this. In fact, apparently Mel Gibson, the Patriot, right? Or the Passion, depending which way you want to look at it, right? Chag Sameach, everyone, right?
Can it be both?
Is there any other kind? A patriotic passion, I don't know. That'd be a fun movie to watch. Mel Gibson, among others. So I actually think, totally from the perspective of criminal justice, there are many people who engaged in bad acts in earlier parts of life who have lived exemplary lives. I don't know why they should be disarmed forever, right? Or using an example, Martha Stewart. God bless Martha Stewart, she's still going, right? Why can't Martha Stewart have a gun? Yeah, it was insider trading, whatever the white collar offense was, okay? In terms of the other element, though, this is kind of small potatoes. The bigger one is ATF, right? Who was nominated to be the chief counsel of ATF? Good friend of mine, his name is Rob Leider, law professor at George Mason, clerk in the Supreme Court for, I think, just was Alito or Thomas, right? He agrees with me on the Second Amendment stuff. And you can imagine having a lawyer at ATF to go through all the regulations, say, oh, this is unconstitutional, that's unconstitutional, and so on. We're not going to enforce this rule. That's going to be the big shift, right? More broadly, the Trump executive order said, go through every regulation and say, does this comply with low propriety? Does this comply with a corner post? Does this comply with, Kennedy v. Bremerton? Like, go through the entirety of U.S. federal laws that we're not going to enforce these regs. I think you're going to see in the next month or so, I mean, just hold your socks, it's going to fly, just thousands of regulations say, we're not going to enforce this anymore. And ongoing prosecutions will just be dismissed. And ongoing enforcement action will be dismissed with settlements not to reopen them. Consent decrees will be flying around. I think you're going to see the consequences of the Roberts Court's decisions implemented in ways that were perhaps very difficult to anticipate.
Yes.
I think you're probably right.
Good. Glad we agree.
Agreement. See, this is great.
I love agreement.
My job is done here.
I had a question about, I think Vanderstock is the case. There
Oh,
was
yeah.
gun regulation that the court upheld, and wondering how that court has even reviewed this.
That was my case, actually, so I got to over
Can you
that
speak
one.
up just a little bit for?
Oh, yeah, the ghost gun case, the Vanderstock case that the Supreme Court just upheld the regulation on production.
Yeah.
I think it wasn't decided on Second Amendment grounds, if I
No.
remember correctly, but I'm wondering if you can speak to how you feel it fits in with the Second Amendment or doesn't.
Well,
I was counsel in the case for disclosure. Yeah.
and we filed a brief. For those unfamiliar with it, ghost guns are homemade guns. They're guns. It's like an IKEA bookshelf of a gun, right? You buy the parts. and
That's
you
what they
put-
say.
Does it work? 'Cause that's important too.
it
Like
does.
my IKEA
It
bookshelf
does.
is like 50-50.
It says more about you than it does IKEA.
This is fair.
Right.
My family's still on the same thing.
But, so, going back several years, these companies decided they had found a way around, really, I'll say 3 key federal laws. The 3 federal laws in question, one requires you to pass a background check at a licensed dealer. If I go into a brick and mortar gun store to buy a gun, I gotta take, with various exceptions not worth getting into here, I have to take a background check. If I pass the background check, I buy the gun. Number 2, there's gotta be a serial number on the gun, because law enforcement recovers the gun, they can use the serial number to trace the gun through manufacturer to wholesaler to retailer, find out who bought the gun, and maybe that's the person who committed the crime, or at least an investigative lead. Number 3, gun stores have to maintain records. They have to keep the records of sale. And so all of those operate to ensure people prohibited from buying guns don't buy them, and that law enforcement has tools to trace. Well, this shadow industry sort of built up that said, you know what, if we take the key component, and it's called the frame of a handgun, if we take the key component of a gun and we don't finish it all the way, and then we disassemble the gun, or we never have assembled it, more accurate way to put it, and we sell that in the kit, let's call it a buy, build, shoot kit, and let's advertise that you can build a fully operable gun, functionally indistinguishable from the Glock with the serial number that you had to pass a background check for in 15 minutes, according to the advertising. In practice, in my experience, it's more like 20, 25 minutes, but leaving that aside. So these companies started selling these products. Now, who would these untraceable guns that don't require a background check be appealing for? Well, probably someone who couldn't pass a background check, because here's a way in 15 minutes to get yourself a gun that fully works and you can't pass a background check. Traffickers, people that want to make a markup and sell guns to people that can't legally pass a background check. So this entire industry, sort of sub-industry exploded. Ghost guns began an exponential increase at the rate that they were being found by law enforcement at crime scenes. And all of a sudden, the foundational aspects of federal gun regulation for more than 50 years, more than anybody in this room has been alive, all of a sudden were being swallowed by a loophole in the law. The Biden administration passed a law that said, look, if you're selling these buy, build, shoot kits, where the only thing you have to do to the key component is drill a couple holes, maybe file off a little plastic, and then you can put the rest of the thing together, you should have a serial number, you should pass background check. That's what the rule said, and it was challenged under the APA, an administrative law challenge, but obviously it implicates Second Amendment issues, guns are involved. And the court upheld the law, or the rule, I should say, and said, we can't have these brazen attempts to undermine the foundational aspects of federal gun law for more than 50 years, in the open. So I don't know if you want to talk about,
We lost.
clients or.
We got our butts handed to us. Look,
Did you make a Second Amendment argument? And
we
if not,
actually
what
did.
was the
There were
strategy?
two groups of counsel. The Second Amendment was raised by, I represent Defense Distributed, one of the common foes of Adam's entity. We did raise a Second Amendment argument. We said that any statute should be construed to avoid constitutional doubt, and that to the extent that we have a right to manufacture firearms, this reading of the statute is unreasonable. No one touched that. None of the courts touched it, but that was in the record. We did put that in our briefing. The challenge with this case, again, the vote was, depending on count, 7-2, but honestly it was 8-1. Alito wasn't really with us in the merits. He kind of was annoyed at the standard review, and so he didn't say anything. So really, we got one vote. We got Justice Thomas, my good friend. He's not my friend, but he's the only guy who wants to rule for us. This was a weird case where for decades it was understood that you could do this. The government sort of ginned up a record saying that wasn't the case. For decades, understanding was you could do this, and Biden suddenly changed it. You say, who else would want to use these guns except for people who are bad, who can't pass the checks? And it's actually not accurate. We have affidavit upon affidavit of people who are law-abiding citizens who like to tinker with guns, they like to play with them, they like to manufacture them themselves, they like to use different approaches. Like, I can't build IKEA for the life of me. My IKEA drawers are falling out.
The Vanderstock decisions, they can still do that. There's nothing stopping them from doing
But
that.
the problem is that these kits become totally unprofitable if you go through the background check process. They cannot be sold. They're so expensive. All the entities that were selling these have pretty much gone out of business. Jennifer Vanderstock, who's Vanderstock, she was actually one of the lead plaintiffs. She was in the court. At one point, John Roberts said, who else wants these but criminals? And she was just so angry. She's like, look at me. I'm right here. I'm in front of you. I'm not a criminal. I think she's a teacher who likes to tinker with guns in her garage on weekends. But we lost. We lost big league. And by the way, Trump didn't change the position. They reversed positions in a host of cases. They did not change position in our case. So that's a loss. There it is.
I can't think of a better note to end on than
I
that.
was gonna say, it seems like we're at time. I want to thank both of our speakers for coming and having such a sort of engaged, candid discussion on both sides, and for your questions and your attendance. I hope you all learned something.
Thank you so much. Thank you, sir.
It's fun. Appreciate it.